My Lady, can I start by addressing the questions put to me by my Lord Wilson before the short adjournment? And can we please look at the trial judge's judgment and the passages that were highlighted? Page 215. My Lord Wilson highlighted the opening words. In this case, I must decide whether a 38-year-long marriage comes to an end as a result of the husband's unreasonable behaviour. My Lord, we say that what the judge here was doing was looking at his task for that day, which was that he had been asked to grant a decree nisi, and that was what his decision was, whether he was, by granting a decree nisi, bringing the 38-year-long marriage to an end.
Yes, it means whether it should come to an end.
Yes, yes. It's whether it comes to an end, it's prospective.
Yeah.
Do I or do I not pronounce decree nisi?
Yes. I mean, he has used the unreasonable behaviour tag, but if you read this sentence like this, in this case I must decide whether a 38-year-long marriage comes to an end as a result of the husband's behaviour, such that the petitioner cannot reasonably expect it to live with him, it would be entirely appropriate. But it's the unreasonable behaviour that rears its head. But certainly in terms of whether the marriage comes to an end, he's not there referring to causation.
It's not say, otherwise it would say has come to an end.
Yes, exactly.
Wouldn't make grammatical sense to use the
Yes,
word comes.
quite, yes.
Of course, we know the only ground for divorce, don't we, Mr. Dyer?
Yes, my Lord.
It's not unreasonable behaviour.
No, it's not.
Anyway, yes?
It's a shorthand, isn't it?
Shorthand.
Because that's his task. His task is to undertake a forensic exercise of the facts, and the fact in particular. And then the irretrievable breakdown ground follows as a result of the fact being proved. So, my Lord, that deals with that. Can I go to the last one that you raised, and I'll come back to the one in paragraph 7 in a moment, but paragraph 15, the sentence you highlighted was the one that followed on from the one I had read before, where he applies the correct test. It's the fact that she does not live with him, the fact that she does not live with the husband has other causes. What that is effectively him saying is that the fact she does not live with him is not because of his behaviour.
Quite.
He's not saying there that he's not linking anything to do with why the marriage broke down. It's just that she's not living with him, but it's not because of the way he's behaved.
The breakdown of the marriage has other causes.
Yes. The fact that
He's looking for behaviour. Is he looking for behaviour causing the breakdown of the marriage?
No, he's simply saying in the fact that she does not live with her husband has other causes simply means that she's not living with him. The reason why she's not living with him is not because of his behaviour.
Well, it has other causes than that she cannot reasonably be expected to live with him.
Yes. The word causes is referring back to why she doesn't live with him, not to the breakdown of the marriage.
What's the difference?
Well, the difference is she's chosen not to live with him. But the main point he's making, bearing in mind the preceding sentence, is that she's not living with him, which has nothing to do with his behaviour. So he's acquitted, effectively, of the behaviour, and she's living for other reasons. She's not living with him for other reasons. And then paragraph 7, it was the sentence, the idea that the lifestyle, whatever it may be, now contributes to the breakdown of the marriage is fanciful.
And the next sentence too.
Yes, the ground is no more than a conventional form of words, with the application to the present.
With no application.
With no application to the present or the breakdown of the marriage at all. This is a difficult one to interpret. I mean, what we would say, it's unfortunate shorthand. Looking at a rather unusual pleaded fact, because it was so historical. Talking about the husband prioritizing his work over home life, etc. I mean, in the evidence, you'll see that the husband had actually retired, as the judge says, many years before, and the children were in their mid to late 30s. So the idea that he disengaged from family life or made his work a priority was a very, very historic allegation or criticism. So he's rather just expressing...
Does the law accept that sometimes petitioners who, faced with behaviour which they can't reasonably be expected to live with, nevertheless do go on living with it and with him?
Yes, I accept that, my lord. But I mean, this was quite historical.
Can the judge so easily knock out, as you say, ancient allegations, earlier allegations, that they were completely dismissed?
Well, my lord, you have to weigh it in the context, because there was other evidence in the case, and one of the points that was made is that every morning of their married life, this couple had tea in bed together, although they had separate bedrooms.
Of course, if you were looking for whether the behaviour caused the breakdown of the marriage, you would be looking only at the more recent stuff, as he did.
Yes.
Yes?
Yes. So, my lord, you have to look at it in the context. When you're looking at reasonable to live with, you have to look at what the other things were going on. I mean, we know mention is made of the holiday in Cancun that the parties had shortly before the wife left, where they shared a bed and had a holiday that, apart from the allegation that was made, was considered to be a happy one. On the day the wife left the matrimonial home, they had their normal ritual of tea in bed in the morning. So, I mean, the judge has got to weigh these points up. The main point I want to emphasize there in relation to this point is really paragraph 10. Because here in paragraph 10 at page 218, the judge is looking at the appropriate test. He sets out the statute, and then he applies, effectively, the Livingston-Stallard test. And as I mentioned earlier, he actually italicized the jury direction.
Does he go on to say, and of course I remind myself that I'm not looking at whether behaviour caused the breakdown of the marriage?
No, he doesn't. But he doesn't analyze any of the complaints and the factual situations as whether they did cause the breakdown of the marriage. He looks at them independently. So it doesn't actually come up when he looks at the facts and makes his fact-finding. So, my lord, we would say that really if he has slipped in paragraph 7, it's only because he was looking at perhaps a rather, as I say, historical complaint. But otherwise, paragraph 1 and the concluding paragraph can be explained to show that he was not looking at the behaviour as being causative of the breakdown of the marriage.
Mr. Dyer, thank you.
Thank you, my lord. Thank you for raising it whilst I had an opportunity to think about it.
Thank you, Mr. Dyer.
I was showing you the Livingston-Saddard test before we dealt with the last point. And I don't think I really need to go into a great deal of detail than to say that the test was approved by the Court of Appeal in O'Neill and O'Neill. My learned friends already mentioned that. That's at page 1288. And then O'Neill itself was followed in Buffery and Butterworth at pages 671 and 676. And the test posed by Mr. Justice Darnity there was, we say, is the correct test. It has stood the test of time. It's expressed in simple language, because we're dealing with fairly straightforward words in this section. And it strikes an entirely fair balance for the application of section 1.2b. And we would invite you to approve that as being the test that should be applied in defending cases. It's not without significance, we say, that in the 1990 Law Commission's report, there was no criticism of the judge misinterpreting the application of section 1.2b. I mean, there's obviously mention made about the linguistic test, but the conclusion of the Law Commissioners was not that the judges were applying the objective test in the wrong way. It was really that the law needed to be changed, and that was a matter for Parliament. And what my learned friend says in his case is that this court should correct the error, referring to the Crown against Jogi case, the joint enterprise case, as if there was an error here, and we say there is no error. It's settled law, and it should continue to be settled law.
How do you balance in the test the second and the third stages? Because the second stage, which you accepted is one of fact, is you look at the effect on the actual petitioner.
Yes.
And if you conclude that the actual petitioner, he or she, is particularly susceptible, you take that into account.
Yes.
So it makes it more likely that they find it unacceptable to continue to live with the other partner.
Yes.
But then there's the control in the third factor, which is that you only give a decree a divorce if it's objectively unreasonable to expect them to continue to live together, or expect the petitioner to continue to live with the respondents. So how much weight do you give to subjective considerations, personality traits, sensitivities which others may not share, and how much weight do you give to the public interest considerations inherent in an objective reasonableness test? There's no indication, is there? It's just left to the good sense of the judge to draw the line in some way. But I mean, different judges might think that individual sensitivities deserve more consideration, whereas other judges might think that the public interest in maintaining marriage deserved greater weight. Nobody seems to have addressed this.
No, but the public interest in preserving marriage should not be a factor in the judge's consideration.
Well, wait a minute. Isn't it? Isn't the reasonableness test a test which contains in it inherently a limitation, at any rate?
Yes.
You don't just get, as you've been stressing, divorce on request.
No.
Or at wish.
No.
So the constraint is by reference to some concept of objective reasonableness, which I assumed, maybe I'm wrong, was based on the thought that marriage shouldn't too likely to be ended. Maybe I'm wrong, but maybe it's something else, in which case, what else is it?
The overarching, looking at the institution of marriage, if I can put it like that, it is not a factor that appears in any of the authorities.
All right, well, what else is it? Well, how do you judge reasonableness?
Well, you have to
Whether
judge...
it's reasonable that a marriage should not be dissolved, or should.
Well, the test the judge is looking at is whether whether the behaviour is such that the petitioner cannot reasonably be expected to live with the respondent. And in conducting that exercise, having made the initial fact findings, the judge has to weigh up, bearing in mind their particular characteristics and idiosyncrasies, whether that test is made out. It's it's not a difficult test.
Well,
It should be quite straightforward.
Maybe it doesn't strike you as difficult because you're more familiar how it works in practice than I am. But at the moment, I'm puzzled. I mean, if you concluded on one view, I think possibly the view put against you, if you concluded that the sensitivity was such that for the particular petitioner,
Yes.
this was a desperate situation which he or she couldn't
Yes.
personally accept or tolerate further,
Yes.
then maybe on one view one would say it must also axiomatically be reasonable to grant a divorce, because who wants to subject an individual to torture, pain?
Yes.
But I don't think that's quite what the statute meant.
No, no, it's not, because there has to be some baseline.
Yes, well, what is it? What's
Well,
that?
I mean, there is no guidance on this, I'm afraid. There is no guidance.
Well, there is support for your view that there has to be a baseline. I think in Balraj
Yes.
at MS at 636.
Yes.
But it doesn't answer Lord Mance's question.
No.
There it says, in order to decide this is the unreasonable, whether it's unreasonable to expect the wife to live with him, in order to decide that, it's necessary to make findings of fact of what the husband actually did, and then findings of fact upon the impact of his conduct on that particular lady. As has been said again and again, between a particular husband and a particular lady whose conduct and suffering are under scrutiny, there is, of course, a subjective element in the totality of the facts that are relevant to the solution. But when that subjective element has been evaluated, at the end of the day, the question falls to be determined on an objective test.
Yes.
So we see that the court saying there are two elements, but Lord Mance's question, I think, remains.
Yes.
What is the weight to be attached to the objective test? It can't be airbrushed out on that approach.
No. Well, this case is a good example of a judge actually finding, having heard the evidence, that there was actually not sufficient evidence here, or the wife hadn't proved her case to the requisite standard to show that she could not reasonably expect it to live with the respondent because of the behaviour allegations that were made were flimsy. So this case is a good example of the judge separating the wheat from the chaff in deciding what were, I'm going to use this word inadvisedly but lightly, serious allegations as opposed to those that were petty. Matters of substance and matters of no great weight.
Well, we all know a drip of comparatively petty things can, in fact, have a very serious impact over time.
The pinprick effect. Yes.
It's a
course,
well-known phenomenon.
the judge says, well, these are isolated incidents. But Mr. Marshall had only been really allowed to present isolated incidents.
Can I just deal with the pre-trial review? My learned friend has showed me his note, and his note for the hearing, or the draft order, showed that he was considering a 3-day time estimate on our side. But we've looked at my learned friend's note for the appellant, and he was looking at a half-day time estimate. And then, as it happened, I suppose the compromise was, I don't think it was quite the way your lordship envisaged it, which is the recorder saying you're only getting a day and no more. A day was set aside. I mean, obviously, contested defended divorces are rare, but they still have to be treated as any other case, which has to be properly case managed and a proportionate time estimate given. I mean, as I don't need to tell your lordships how busy the Central Family Court is. And frankly, if you have a day, and you know you have a day, and there are no other witnesses, and you have 27 allegations in your petition, and you only know, as you will know, you won't be able to go through all 27, you have to craft your case accordingly. And you have to
But if your case is actually based on the fact that you have 27 incidents spread over a comparatively short amount of time, set against the background of the general allegations that you make, isn't it rather difficult? Because we're back to, I don't like this word pinprick. It's a drip.
It's a Scottish Scottish expression, I think.
Well, pinpricks happen, of course, but it's the cumulative effect of behaviour which, if it only happened once, you would laugh off. But if it happens many times, it's not laughable off. It's unacceptable.
But Melody, it still goes back to my point that when you know your task, which is you have a day to present the case or to deal with the case, and you effectively will have your client in the witness box, and the judge invited Mr. Marshall for his client to give evidence in chief, which is unusual because he wanted to get a feel for the witness, 5 to 10 minutes, he said. There was ample opportunity, we say, to have for her to have amplified the cumulative effect point in evidence in chief, but that didn't happen.
Were you right to say in your case, paragraph 51, that the recorder did direct that the parties should be the only witnesses?
Yes. I'm not sure.
What was your Admirable Junior doing, submitting at length to Judge Tolson, where's the corroboration? What was he doing? Wasn't allowed to be corroboration.
No, I can see that, Lord. I'm not sure whether that was imposed by the recorder or that was agreed.
Well, that's not the point I'm making.
No, I can see your point.
Very well, thank you.
But just
you suggested in your or your side suggested it should be 3 days, did you?
Yes.
And what the circuit judge said, no.
I think it was a conversation between counsel.
What was it? Who was it?
It agreed it would be a day.
There was a compromise between counsel, and who handled the pre-trial?
Miss Recorder Campbell.
The recorder, yes. So and was that, you can't remember whether that was his suggestion or
her suggestion?
Her suggestion.
Yes. I don't know. Can I just look to my junior?
Sometimes the reason for a time estimate is to get the case on more quickly.
Yes.
I don't know whether that featured in this.
I don't know.
Well, you weren't there, were you?
I weren't there.
It's a bit unfair to be asking you these questions.
I can obviously discuss it with Maloney Junior and let you know.
But there are a great many considerations that come into this sort of thing.
Yes.
Some of them those that my Lord mentioned before the short adjournment.
Yes.
Some of them those my lady has mentioned. There are a lot of considerations.
I mean, there was no suggestion that either side wanted to call any witnesses. So to that extent, no one was shut out from calling a witness. But I do go back to the point I was making, that you have to set your course knowing what your destination is. And in this case, a day was set aside. The parties had done short statements. My learned friend opened the case on the basis he was not going to go through all the allegations. He said he was going to do with 2, 3, or 4 of them. So, my lord, at the end of the day, a defendant divorce, like any other case, is a forensic trial where you have to prove your case. And what happened in this case is that the wife failed to do so. And although obviously the result is seen in very emotional terms and perhaps surprising to perhaps the wider public, it is nonetheless a legal process that we have to go through. Can I move on to my second topic, which is the subjective interpretation sought by the appellant? I must confess to finding some confusion as to precisely what my learned friend is seeking. He talks about a modest shift of focus, to use his words, but that is certainly not what is put forward in the appellant's case, because the tests that are proposed in the written case are far more wide-ranging than just a modest shift of focus. And if I could ask you, please, to look at page 85, at paragraph 47. Looking at the last sentence, beginning, so if a petitioner, this is paragraph 47, one of the tests that's proposed here is, so if a petitioner honestly or genuinely feels that he or she cannot live with the respondent as a result of the respondent's behavior, however mild that behavior might objectively appear, it is very likely to follow that it is not reasonable to expect the petitioner to live with the respondent. I mean, that we say is a very, very subjective test indeed. It strips out all objectivity and it emasculates the role of the judge in the second stage. Because the test that's posed there...
At the third stage, I think you mean?
Yes, the test that's proposed there, the judge is replaced by the petitioner in deciding the key question of whether he or she can reasonably be expected to live with the respondent.
I expect you'd say the same about the last sentence of paragraph 48, Mr. Dunn.
Yes, exactly.
Put more colloquially.
Yes.
And Mr. Marshall does put it as a question, but I think really it is a proposition that he was then advancing. Can a petitioner reasonably be expected to live with a respondent where the respondent's behaviour, as a matter of fact, makes the petitioner miserable?
Yes.
Whereas, as a matter of fact, petitioners genuinely concluded the parties can't live together, the marriage is over. Well, like you, I listened this morning and felt that he wasn't going as far as that.
No.
He was accepting an objective element.
Well, he even used the expression overarching objective test, which
Yes.
is what I had written down last week when I was preparing these submissions. So we seem to be in agreement with that. But that's certainly not what's here, because what is being proposed here is really that any behaviour on the part of the respondent that the petitioner feels that he or she cannot live with is enough for the fact to be made out. And this is why we say this test at this level would amount to divorce on unilateral demand, which is certainly not what Parliament intended. The only fact that Parliament intended would provide divorce on unilateral demand is of course section 12E, 5 years separation which does not need consent. So you cannot turn section 12B into effectively having the same impact as section 12E in terms of how the respondent is treated. And also when you look at the two tests here, paragraph 47 and 48, you can really ask the question, what behaviour facts would fail to meet the test?
Well, you can see, I think you can see that from the last sentence in paragraph 86 on page 102. The only question is whether the effect, i.e. impact of the behaviour on this petitioner is such that they can't reasonably be expected to believe. You don't look at the quality of the behaviour at all. You say, how has the petitioner reacted to that behaviour, however
Exactly. Yes.
minor it might be?
Yes. Yes, quite. And if you just go for a moment, please, to the intervener's case, just to look at the test that they pose, page 155. This is paragraph 57. They put the test even higher. They say the answer suggested on behalf of resolution is that, as explained in paragraph 49 above, in a section 12B case, the entire focus should be on the petitioner's capacity to endure the behaviour of the respondent, irrespective of how good, bad, reasonable or unreasonable that behaviour might be when viewed from an objective perspective. So this effectively excises from the statute the words reasonably be expected. It denudes the test of any objectivity at all.
Well, it rather begs the question of what's meant by capacity to endure. I mean, if it just makes you sad, that's one thing.
Yes.
If it actually makes you ill, that's another thing.
But it's not applying any objectivity.
Yes, but objectively, it might be thought, might not be thought, I know not, but it might be thought, that behaviour X, especially if persisted in over a period of time, which simply makes somebody feel unhappy, is one thing. Behaviour X, again, persisted over, which makes the petitioner ill, is another thing.
Yes, I can see that, but the way this is worded, when it talks about the entire focus.
But when we've got to the stage where we're actually construing
Yes,
written
quite.
submissions
Quite.
as if they were statutes, we've got a long way away from what we're
Yes.
supposed to be doing.
Quite. I'll get back on piece. I mean, the point I'm making is that when you make it so subjective, you just completely go away from the words of the statute, which plainly poses an objective test. Could I ask you please to turn to page 1297 to look at pheasant, which is in the Authorities, Volume 3, at tab 39.
Remind me, in how many of the reported cases, the ones that we plough through time and again when we consider this not a question, has a decree actually been refused?
In pheasant, it was refused.
I know.
Yes.
That's why I'm asking.
Can I get my junior to do a ready reckon? I think it's a handful. It's certainly not that many.
This is reported contested cases.
Yes.
Yes.
Yeah, obviously, yes.
They tend to get reported more in the newspaper than in the law reports.
I was thinking of the law reported cases.
Yes.
The ones that we've been looking
Yes.
at. The ones we've got in our bundle.
Anyway, pheasant.
Yes, pheasant is an important case. It's also one of the earliest cases after the 1969 Act came into effect on the 1st of January of 1971. As you can see, the trial judge was Mr. Justice Ormrod, as he then was, and he has provided in his judgment a very insightful judicial commentary on the 1969 Act. And you can see just briefly the facts, because they were unusual. The husband was the petitioner. The judge found him to be an unstable, emotional, and irrational person. And the judge believed the wife, respondent, and said the petition was not proved. If I could ask you to turn, please, to page 1299, just to look at these submissions that were made on behalf of the husband, because these submissions are analysed by the judge. And at the top of page 1299, between A and B, you can see it was submitted that this particular petitioner is miserable, he's a man of acute sensitivity. And then if you go down to the next paragraph, it was boldly submitted at C that Parliament clearly contemplated that if a man can truthfully say that the behaviour of his wife makes life so unbearable that he can no longer live with her and that the marriage is dead, he's entitled to a decree. And then if I could ask you please to turn to page 1302, just below F. The judge said, Mr. Trotter has not contended for his construction and concedes that the word expected is used in its other sense, which approximates to required. He submits that the matter should be approached very largely, if not entirely, from the point of view of the petitioner, that the court should consider in effect whether it was reasonable to require this petitioner to go on living with this respondent, having regard to her behaviour, giving that word its widest meaning and including both acts and omissions. This is sometimes called the subjective in contrast to the objective approach, but so stated, the antithesis is, in my opinion, misleading. In matrimonial cases, there are two subjects to be considered, and moreover, two subjects whose personalities are constantly interacting with one another throughout their relationship. In my judgment, this construction is untenable for several reasons. It places the primary emphasis upon the petitioner and his personal idiosyncrasies, whereas the paragraph clearly places the primary emphasis on the behaviour of the respondent. A respondent whose behaviour is beyond reproach by any standards other than the petitioner's would be liable to be divorced without any possibility of resistance, except to rely on section 2.3 and to try to show that the marriage has not finally broken down. Mr. Trotter faces this and says that under the modern law, the court is concerned only to crush empty shells. Had this been the intention of the statute, paragraph B need only have provided that the decree could be granted if the court is satisfied that the petitioner finds life with the respondent unbearable. Once again, the 4 paragraphs would be surplusage and the court would be faced with an untriable issue. And that in my submission, very succinctly sums up the reasons why a wholly subjective analysis, or putting far too much weight on a subjective analysis, is untenable. Because what Pheasant establishes, that if you have a subjective test purely from the petitioner's point of view, in substance, there would be no test at all for the behaviour fact. And perhaps more significantly, in the context of the Act as a whole, it would pull the rug out from beneath all the other 4 facts in section 1.2. So it effectively undermined the concept of the current law.
By that it means that the mere presentation of a petition would effectively prove all that was necessary.
Yes. If you could say, I'm miserable, the marriage is over, I've had enough, his or her behaviour is such that I cannot be expected to live with it, and I'm telling you that, and you must work on the basis of what I'm saying, because it's a subjective test, then you'd get your decree. So it would effectively mean, taken to its furthest length, there would only really be one fact, namely the behaviour fact, based on the petitioner's unhappiness and disenchantment with the marriage. That's what that would involve. I mean, why would a petitioner bother to rely on any of the other facts? There'd be no need to wait for 2 years with consent, certainly not 5 years. You just put in your behaviour petition on the basis of what you are personally affected by, without any objective appraisal. And what we submit is that Parliament did not provide for divorce, either as a ground or indeed as a fact leading to the ground, based on unilateral unhappiness. And yet this, we say, is really what this appellant's case amounted to before the judge. And that sort of case was the very case that was dismissed in 1971 by Mr. Justice Ormerod. Can I now turn to my next topic, which is the approach taken by the trial judge to fact-finding in the trial? And we've already touched on some of those points already.
Yes.
There is, of course, an important point of principle here, and that is whether the appellate court defers to findings of fact made by the trial judge. It can only be, we say, in the rarest of cases, and not this case, where the appellate court was convinced that the trial judge was wrong, that this court can revisit the factual findings. There have been 4 cases before your lordships in the last few years. I'll just mention them and give you the page references. Re B, that's a child care proceedings. That was in 2013. That's at page 1697. McGrady at page 1174. That was also in 2013. Henderson and Fox.
McGrady?
Sorry?
Wasn't it McGrady?
McGrady. Sorry,
Double D, McGrady.
Thank you. I'm corrected. The third case is Henderson and Foxworth Investments, 2014. That's at page 1297. And then the most recent case, the Royal Bank of Scotland against Carlisle, 2015, at page 682, where my Lord Hodge gave the leading judgment. And that was an authority that we referred the President to, and he has cited that authority in his judgment. So I don't propose to revisit that. But could I ask you please to look at Re B, which you'll find at page 1697, which is in the Authorities, Volume 5. And can I take you to, please, page 1719, which is paragraphs 52 and 53. This is the judgment of Lord Newburger, and my apologies to Lord Wilson, who I had attributed with this passage in our written note. It's paragraph 52, where he talks about the restriction on fact-finding in this court. He said, there is no question of this court interfering with, or indeed being asked to interfere with, the findings of primary fact made by the judge. Bearing in mind that it is a second appeal tribunal, the Supreme Court is virtually never asked to reconsider findings of primary fact made by the trial judge. The Court of Appeal as a first appeal tribunal will only rarely even contemplate reversing a trial judge's findings of fact. Then he said, as Baroness Hale and Lord Kerr explain in paragraphs 200 and 108 respectively, this is traditionally and rightly explained by reference to good sense, namely the trial judge has the benefit of assessing the witnesses and actually hearing and considering their evidence as it emerges. And then he sets out there the rationale, which I can just précis, as for reasons of policy, cost, delay, and practicability. Then if I just ask you to turn over a few pages, please, to page 1733. At the top of the page, this is in the judgment of Lord Kerr, where he looks at the matter from a very practical point of view. Starting at the top of the page, he says, although an appellate court is competent to hear appeals against the findings of fact that a judge has made, of necessity its review of those findings is constrained by the circumstance that usually the initial fact finder will have been exposed to a wider range of impressions than influence a decision on factual matters that will be available to a court of appeal. This is not simply a question of assessing the demeanor of the witness who gave evidence on factual matters, although that can be important. It also involves considering the initial impact of the testimony as it unfolds. Did it appear frank and candid, spontaneous and persuasive, or did it seem to be contrived, lacking in conviction, or implausible? These reactions and experiences cannot be confidently replicated by an analysis of a transcript of the evidence. For this reason, a measure of deference to the conclusions reached by the initial fact finder is appropriate. Unless the findings is unsupportable on any objective analysis, it will be immune from review. And then if I could ask you please to turn to page 1795 in the same bundle. This is at tab 49. This is a case in the House of Lords, Smith, Newcourt Securities versus Citibank. where again the issue of this time the House of Lords, looking at the facts again, and it's dealt with by Lord Steyn at page 1795. And this, of course, is the position we're in here, because there has already been an analysis of the facts, again, in the Court of Appeal. It's quite a long passage. If I could just ask you to look over the page, please, at 1796. Just between A and B, Lord Steyn said, while the jurisdiction of the House is not in doubt, it is most reluctant to disturb concurrent findings of fact. There are two reasons for this approach. First, the prime function of the House of Lords is to review questions of law of general public importance. That function it cannot properly discharge if it often has to hear appeals on pure fact. This point is underlined by the fact that despite the economy of presentation of counsel, the hearing on liability lasted more than 3 days. Secondly, in the case of concurrent findings of fact, the House is confronted with the combined views of the first instance judge and the Court of Appeal. A suggestion that the House can be expected to take a different view on concurrent findings of fact generally gives rise to an initial sense of disbelief. And I would invite you to have a sense of disbelief in being asked to reconsider the facts in this case.
Can I put down a marker, because there's always a danger when one has general statements of this sort, and this is a commercial case. There is an important qualification which perhaps doesn't apply in this category of case, where you have a situation which is extremely well documented.
Yes.
Lord Justice Robert Gough, as he then was, said in the rather well-known Armagas and Mundergas case that it's a helpful starting point to the analysis of oral evidence, which can often be convincing after the event, but nonetheless incorrect.
Yes.
Here's the documents.
Yes.
And in fact, we applied that principle in the light of concurrent findings in the Privy Council in a case. We also looked at McGrady in a case called Central Bank of Ecuador against Conticorp a couple of 2 or 3 years ago. So that I don't say it because it's directly relevant. I just say it because I think it's useful to bear in mind that the context is important.
Yes, I'm grateful, Lord. Thank you.
But of course, there are also differences between findings of fact, i.e. what happened,
Yes.
and the evaluation of those findings
Yes.
of fact and the application of judgment and tests to those facts. There are very different considerations.
Yes. Yes, I accept that.
And that's what we're talking about here.
Yes, but of course, the value judgment is done by the trial judge.
It is, and he has had great benefits in doing that value judgment, obviously. But nevertheless, it is something with which an appellate court is, from time to time, and with reluctance, able to disagree on a slightly different approach, in fact, a very different approach from the one that you're talking about, which is the finding of primary facts.
Yes.
I think the leading authority, there may be an endorsement of it, but there's a judgment in a case called Assicurazione and something or other, isn't there, Lord Clark's?
Sure. Well, in Re B.
Yes, well, Re-B,
Plenty,
yes.
plenty
Yes, quite.
to that effect.
Yes.
Yes, I wonder how much we can make of concurrent findings of fact here, where one of the criticisms that you're facing is that there are very few findings of primary fact in relation to the allegation.
Can I show you how the Court of Appeal dealt with it?
Yes.
Because there was quite an extensive analysis by the President of the same challenges that are being made before you now by my learned
Yes.
friend in relation to the facts. And that's at page 203 in the Court of Appeal judgment. These 2 pages that you will have open, 203 and 204, show that the President dealt with each ground of appeal raised in relation to fact-finding in some detail. And he went through the judgment, and he found that none of the criticism was justified. He dealt, as you can see, with the failure to make findings of fact generally, dealt with the wife's subjective characteristics, and then between paragraph 71, he dealt with the cumulative effect. So this has already been through a very fine mesh in the Court of Appeal and found to lack substance. And we would submit it would not be appropriate for this court to undertake a similar exercise when the President has undertaken such a detailed exercise.
One of the charges is that it's simply too light on the wife's characteristics, and you've got to defend the judgment from that. And you do rely, obviously, on the judge saying in paragraph 14, I can also find the wife to be more sensitive than most wives. But then he goes on to say, Mr. Dyer, it matters not.
That's because
It does matter, doesn't it?
But, my lord, I think if you read on, he says it matters not because he didn't find the particulars that she was, or the criticisms that she was making to be significant. I think that's how that passage ends in the judgment. Well, when it comes to the fact-finding analysis and the judge's finding, the most important finding that he made, which is a very high hurdle for my learned friend to get over, is that the judge found that the wife had exaggerated the context and the seriousness of the allegations to a significant extent.
Yeah, I think I noticed he said, I can also find the wife to be more sensitive. In other words, effectively assuming
He
that.
made an
When he
answer.
said it matters not is assuming that, as I read
Yes.
it. Yeah.
Yes, exactly. But that finding of fact is crucial because every criticism a learned friend makes, oh, this wasn't done or that wasn't considered, well, that's because the judge didn't really believe her or thought that on important matters like the behaviour facts that she was relying on, she'd over-egged the pudding.
But then when you read the 100 pages of transcript of evidence, there's so little difference between the parties. They remember these incidents, by and large, although your client has forgotten some of the detail. But as I think the judge said when he refused to elaborate his judgment, I mean, basically, these were just different emphases
Yes.
on commonly recorded, commonly remembered incidents. So upon that, to pile a finding of exaggeration is difficult. And indeed, isolated incidents, I've made the point, and if you've answered it, I do apologise to you, Mr. Dyer. Isolated incidents, Mr. Marshall was asked for isolated incidents. He gives them, and then the judge says, they're isolated. What do you say about that?
Well, my lord, he did make a specific finding of fact in relation to one of the incidents. That if we can look at the judgment in relation to this is page 220, paragraph 14. He sets out the top three allegations, the airport incident, the restaurant incident, and he says, I'm not going to overburden the judgment by setting out the pleaded allegations in full. And then he says, the airport and restaurant incidents are examples of two arguments in public which allegedly show the husband being domineering, and the pub incident is an evening of obvious silence over dinner. This case might have found favour if I had been satisfied both that the incidents were examples of a consistent and persistent course of conduct and took place as the wife described. I do not so find. Having seen him, I hope the husband will forgive me for describing him as somewhat old school. I can also find the wife to be more sensitive than most wives. It matters not. The reality remains that these were, in my judgment, isolated incidents consisting of minor disputes. And then he goes on to the pub incident where he effectively believes the husband. He says, in the case of the pub incident, if they sat in silence whenever they were out for a meal, the wife would have told me so and pleaded other examples. The husband claimed that he had been tired on this particular evening, and I accept that evidence. Whereas the wife was saying that was an example of him being moody. And then he says the wife has cherry-picked one unsuccessful evening and entered it in her diary. It is an illustration of her approach and the weakness of the case. And then he deals with the airport incident being a minor dispute at the end of a holiday, and just merely examples of events in a marriage which scarcely attract criticism of one party over the other. So, Lord, he has looked at it in the round. He doesn't have to go into an enormous amount of detail. It's obviously, it's impressionistic. It's impressionistic.
Thank you.
And I would submit that the brevity of the judgment reflects the fact that the judge didn't find that the petition was one of substance. So in conclusion on this particular topic, what we say is that the trial was a forensic legal exercise with obviously the petitioner having to prove her case. Of course, we are used to dealing with undefended cases going through an administrative process, but the law is the law, and when the petition was obviously when it was clear the petition was going to be defended, the wife amended the petition, and perhaps rather than concentrating on quality, she decided to concentrate on quantity. And there were this long amendment with 27 particulars. And then when it was agreed there was going to be a one-day time estimate, the wife really had to trim her case to the time that was available. And if her case was, it was a matter of the husband's behaviour such it was having a cumulative effect on her, then she should have dealt with it accordingly. But my lord, you can't now set that record right, because obviously we've had the judgment, we've had the Court of Appeal. We say that the facts should remain undisturbed, and the focus for this court is really, was the test the right test? Did he apply the correct test? And if you find that the correct test is the Livingston-Stannard test, then he did. Can I move on next to convention rights? Article 8 and Article 12. The intervener is submitting that the provisions in Section 3 of the Human Rights Act should be invoked, and that Section 1.2b should be read down and interpreted to provide a subjective test, which we say would effectively excise from the statute, obviously, the words cannot reasonably be expected, and more significantly, take away any objective judicial control on exit from the marriage, because it would be such a subjective process. The Strasbourg jurisprudence has held that the scope of Article 8 rights and Article 12 rights cannot be interpreted as conferring on individuals a right to obtain a divorce. We would also say that Article 12 is not engaged here because the appellant's evidence at trial clearly was that she did not want to get married again. So we cannot see how her rights to remarry could be infringed if her clear evidence was that she does not want to get married again. It's an entirely hypothetical event, and we say that she is not a victim within the meaning of the Convention. She wants a divorce, but not for the reason that she wants to remarry, which is very different to the two cases I'm going to show you before the European Court. The Strasbourg jurisprudence has been clear and consistent over the last 30 years. And it started with the case of Johnston against Ireland, which you'll find at page 1066. And perhaps just for convenience, you'll find it cited in the President's judgment at page 205. I don't think we need to turn up the actual law report. The point in Johnston was quite straightforward, because at that stage there was no divorce in Ireland. No divorce was available. And Mr. Johnson brought his application to the European Court on the basis that his Article 12 rights and his Article 8 rights were infringed. The court held that the framers of the convention had deliberately excluded from the ambit of Article 12 a right to have the ties of marriage dissolved by divorce. It was a specific exclusion. And in Johnston, what the European Court did was they read the convention as a whole and held that if a right to divorce had been specifically excluded from Article 12, then a right to divorce could not be derived from Article 8, which was a provision of far more general purpose and scope and was a qualified right anyway. So Johnson effectively held that if the front door is closed by Article 12, you cannot get in by the back door through Article 8. The next case of importance is one that actually was hot off the press when we were before the Court of Appeal. It's a case called Babiage against Poland, and it was issued on the 10th of January of 2017, and we were in the Court of Appeal in February. And you'll find that at page 598 in the first volume of the Authorities Bundle. This is not a decision of the Grand Chamber. If I could just explain the facts. The husband filed for no-fault divorce in Poland, but the wife refused to give her consent and wanted to reconcile. He then failed to prove a fault-based divorce under the Polish statute, and his petition was dismissed. After 3 years of proceedings, including an appeal, I think to the highest court in Poland, he remained married, and yet he wanted to marry or remarry the mother of his child. The Polish court had found that there had been a complete and irretrievable marriage breakdown. He then took his case to the European Court on the basis of a breach of Articles 8 and 12, and the majority, by 5-2, found there was no violation of either right. And the court in Babiage, or the majority in Babiage, followed and applied Johnston, holding that if the provisions of the Convention cannot be interpreted to provide a right to a divorce under domestic law, then a fortiori they cannot be interpreted as guaranteeing a favourable outcome in divorce proceedings. And they held in the case that the Article 8 rights were not absolute but qualified, and a fair balance has to be struck between the competing interests of the petitioner and the respondent. And Polish divorce law was very detailed, and it was meant to protect the weaker party in the proceedings. And they concluded that what had happened here, that despite the extensive evidence that was put before the domestic courts, the husband had simply failed to prove his case under Polish law. And the fact that Polish law did not operate a res judicata rule meant that he could reapply to the Polish court at a later stage when circumstances had changed, when the court might grant a decree on the basis that the wife was not reasonably giving her consent. So there was no insurmountable obstacle to obtaining a divorce at some stage. There's just one passage I'd just like to refer you to, please. It's paragraph 54 of the judgment at page 609. It reads, "The court is well aware that the applicant had a daughter with his new partner, that he was apparently in a stable relationship, and that the domestic courts had acknowledged a complete and irretrievable breakdown of his marriage. This, however, does not detract from what is mentioned above. To contemplate otherwise would mean that a request for a divorce would have to be allowed, regardless of the procedural and substantive rules of domestic divorce law, by a person simply deciding to leave his or her spouse and have a child with a new partner." So what Babiage demonstrates is that because divorce is a morally problematic issue that involves a conflict of rights, the European Court grants member states a wide margin of appreciation in framing their divorce laws. Not surprisingly, bearing in mind all the divorce laws of the member states are different as to when you can bring a divorce and also on what grounds. But the fact that the domestic divorce law provides for certain conditions and requirements to be met did not per se infringe Article 8 or Article 12 rights, as a fair balance has to be struck between the competing interests. Interestingly, the court gave an indication of the sort of cases where the rights might be infringed, and these were examples they said that they might examine with more scrutiny in future. And the first one was if there was a case of an unreasonably long divorce proceedings. But of course, that's not a situation that's going to arise here, because in February 2020, the appellant will be able to issue a petition based on 5 years separation without needing the respondent's consent. The second reason also is linked to that. They said they would look at a situation where cases where the lack of consent of an innocent party was an insurmountable obstacle to granting a divorce would also potentially involve an infringement. But again, obviously there is no insurmountable obstacle in this case. In many respects, Babiage was a stronger case than this case for rights infringement, bearing in mind that the husband in Babiage had for many years formed a new family unit and had a child. He wanted to remarry the mother of the child. His remedy was to bring further proceedings with an unknown outcome, whereas of course here the appellant can issue the petition in February 2020. So, my Lord, in summary, the Strasbourg jurisprudence in relation to Article 8 and 12 cannot be interpreted to provide a right to obtain a successful outcome in divorce proceedings, still less a divorce based on unilateral demand if the domestic law does not expressly permit it. And we submit that what the European Court has done in Johnson and Babiage is to use the well-known expression, drawn a line in the sand, in relation to these points, and that these cases represent clear and constant authority from the Strasbourg Court, which we would invite you to follow in accordance with the mirror principle. I'm sure this passage is referred to you on many occasions, but could I just refer you to the passage in Manchester City Council and Pinnock about the mirror principle? Unless you say, well, we've heard it so many times.
Does anybody want to hear?
Heard it so many times.
Thank you.
Thank you.
Thank you very much. Can I next deal with the intervener's case under Section 3 for a read down? Two simple points here. When it comes to interpreting section 1.2, you obviously have to read it and give effect to it so far as it is possible to do so in a way which is compatible with convention rights. But if, as we've just seen under the Strasbourg jurisprudence, there are no convention rights to obtain a divorce and no right to obtain a successful outcome in divorce proceedings, then as a matter of pure logic, the section cannot be read down and interpreted to provide the appellant with a divorce, because you would be providing a remedy for a convention right where one simply doesn't exist. The second point is the easiest way to address the intervener's case is to ask the question, if section 1.2b was before that court, would it withstand scrutiny? And the answer is yes, it would, for two reasons. One, because of the case of Babillage, and secondly, because of the wide margin of appreciation given to the member states to draft their divorce laws as they consider appropriate. So, my Lord, there really is no basis, we say, in law to write down or read down this section. Can I now turn to my last point, please? This is the always speaking statute. Now, it's been said on obviously many occasions that the Matrimonial Causes Act is an always speaking statute. And points taken by my learned friend and the intervener look at, or say by way of illustration, look at White, look at Miller-McFarlane. But there is a great deal of difference, we say, between section 25 and section 1.2. Section 25 is a very open-textured section. It lists matters to take into account in the exercise of a judicial discretion. And when the tailpiece was removed from section 25, the whole process became rudderless. No one quite knew what the objective was because the tailpiece had gone. So it's not surprising that when the court came in those cases to provide some guidance, they could do so because there wasn't any direction available at the time. Those cases, the lacuna left by the tailpiece being removed effectively invited a fresh judicial evaluation. But contrast that with section 1.2, where the words are plain and clear and involve a fact-finding exercise and a value judgment. The section is not concerned with the exercise of a discretion. It's not concerned with judicial guidance to create boundaries within which a discretion is exercised. It's simply a value judgment. And although my learned friend talks about modern social changes, it's when you analyse that, what does that really mean? I mean, what the judge has to do is to make a value judgment based on what a modern thinking person would consider to be reasonable or not.
Was he saying that women in 2018 cannot reasonably be expected to put up with behaviour that they might reasonably be expected to have had to put up with in 1969?
Yes, but Lord, we say that really doesn't need to be stated. That should be obvious from the application of the test, because that's what the test provides.
So it's Lady Hill's point. It's not altering the test. It's altering the application of the test to the facts. Yes. So the test remains the reasonableness consideration.
The test remains the same. Yes.
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 But people's attitudes and behaviours do develop and change.
Oh, very much so.
Absolutely.
Yes, I accept that. But the judge trying the case would obviously take that into account. Unless there's anything else I can assist, those are my submissions.
Thank you very much, Mr. Dyer. I think Mr. Dunlop wants to draw something to your attention.
Yes. Sorry. In answer to your question, lady, about how many petitions have been dismissed,
Yes.
there are two of them. One is Pheasant and the other is Buffery.
Thank you.
Thank you.
I was going to say one should add. Oh, I'm so sorry.
Well, I was going to ask Mr. Dunlop if he wanted to add anything to what his leader had said, but he's done it. Thank you.
So sorry. I was going to add only to the list Owens, I suppose, as a reported case. But, yes. May I just pick up on one point this morning? I think it was in answer to Lord Hodge on how and in what way gravity might fit in. And I made reference to an observation. In fact, it's in the case of Buffery at 673 that some conduct may be of and in itself so grave that would provide an easy answer to the question, is it reasonable to expect the petitioner to live with the respondent? Of course, reminding ourselves that Buffery approved O'Neill approving Mr. Justice Dunn in Livington Stallard, who said gravity is immaterial.
Well, it went on to say something that it might.
It did, my lord.
That it might be a factor, but it's not by itself. Wasn't that the phrase, by itself
But
test?
Yes, and I suppose the simple point is, if one has regard to issues both of the cumulative impact and the subjective impact, then one can readily see why gravity is only a factor. And it addresses my Lord Mance's point as to my learned friend's suggestion that Pheasant would effectively, issuing a petition, would of and in itself entitle the petitioner to a divorce. That plainly can't be right, and it's not our suggestion. Paragraphs 47 and 48 in our written case do put our case quite highly, and I specifically, in opening the matter to the court this morning, qualified that in a number of ways, one of which was that it's not determinative, and I accept that the observations of Mr. Justice Ormerod, as he was in Pheasant, must, of course, be right so far as they go. Pheasant slightly fell out of fashion, if I can put it that way. I think this morning I referred to pheasants falling into traps, I think, and that seems to have generated some responses outside this courtroom. But Pheasant fell out of favour because Mr. Justice Ormerod went on, as we can see on page, and this is Authorities Volume 3, page 1303 at the bottom.
It was causation, I think, is it?
I'm so sorry.
Is it the causation point?
No, well,
Is it the constructive desertion?
yes, it's the constructive
Yeah, well,
desertion.
we understand that.
Yes, and so in a sense it fell out of favour. I accept that the observations at the top of page 1303 in response to submissions from Mr. Trotter must be right, in the sense that of and in itself, the mere assertion that subjectively one cannot bear to continue to live with one's spouse doesn't satisfy section 1.2b. And we can see, actually, I think my learned friend took you to it in passing, I don't propose to do it in detail, but if one looks at the findings that Mr. Justice Ormerod made on page 1304, effectively his lordship found that there was no behaviour at all. And it's no bad thing perhaps to bear in mind that the complaint that the husband was making was not a range of conduct or behaviour, but simply that the wife didn't provide a level of spontaneity and affection which he craved. And although we haven't taken the court to it, in the case of cats, and this is in volume 3 at Divider 29, page 1113. Sorry, I beg your pardon, 1103. Sir George Scott Baker, then President, actually concluded that, and we can see it at the top of the page, behaviour is something more than a mere state of affairs or a state of mind, such as, for example, a repugnance to sexual intercourse or a feeling that the wife is not reciprocating his love or not being as demonstrative as he thinks she should be. And so at the time, assuming the President was right, the conduct of which Mr. Pheasant made complaint was not regarded as any sort of conduct at all, because the same complaint was being made. And indeed, on the facts in Pheasant, Mr. Justice Ormrod found as a fact that the wife indeed had provided as much love and affection as in the extreme circumstances created by the husband she reasonably could. Now, and so we accept that even if greater weight is given to the subjective impact in the way that I opened the matter to you this morning, there still has to be behaviour. It's as simple as that. And we looked briefly...
Well, that's not much of a concession.
No, it's not, but it's a recognition that in the instance that my Lord Manns postulates, which is the mere issuing of a petition, if one took the unilateral expectation of divorce to its nth degree, that the mere fact that I was to say, I am so unhappy and so miserable, therefore I'm entitled to decree, that's not our case. That would fall into the dead marriage category, with which the authorities are variously concerned, in which the judges say, well, simply getting bored with each other and growing apart, a dead marriage, you simply have to wait 5 years unless there is consent after 2 years in the usual way. It doesn't entitle you to rely on 1(2)(b). And in the circumstances we briefly looked at this morning, in Thurlow, excuse me, I'm too sure where it is at the moment. Thurlow is in bundle 5. The court was, albeit in extreme and sad circumstances, and I think Lady Hale said this morning that the truest innocent wife, as it were, was Mrs. Thurlow, because she was the lady who suffered from extreme physical and mental health problems. And as you will be aware, the case was being argued for the respondent by, by the petitioner, for the petition by Mr. Joseph Jackson, Queen's Counsel, and there was the official solicitor was arguing for the wife. And if one goes to page 1827, it's at that point where Mr. Justice Rees considers the issue of whether behaviour which is not intentional or is a result of misfortune of the sort we've been discussing could of and in itself be sufficient. And the issue really was influenced by regard to the old cases in relation to cruelty, and whether the same test should apply. And indeed, Mr. Justice Rees said no. In those circumstances, one makes all due allowance, as it were, for the circumstances, but one still might be justified in making a finding that it was not reasonable to expect the petitioner to remain living with the respondent. The official solicitor had also postulated the situation in which a vegetative state was brought about by a road accident, for example, where there was absolutely no conduct at all, even though the consequences for the petitioner might be the same, because one is left in effectively a broken marriage in terms of association and all that the marriage would normally entail. In fact, Mr. Justice Rees said, well, I prefer not to decide the point, but at the bottom of page 1828, he did say, when that case does arise, just above letter H, when that case does arise, I apprehend that the petitioner may face very considerable difficulties in establishing that there was no or any sufficient behaviour towards him, or how alternatively such behaviour, etc., that was justified a conclusion that the petitioner could not reasonably be expected to live with him. So we do accept that there must always be some sort of behaviour. It doesn't have to be serious, and if one goes through the Balraj, as it were, test, do I mean Balraj? Yes, I do.
Yes, you do.
One would have to assess the behaviour, one would have to assess the impact, and at that point ask, is it reasonable? Now, having assessed the conduct and having assessed the impact, as one must, it would, in my submission, be counterintuitive then to introduce at that point some unspecified threshold. What is that threshold? To go back to the example we discussed this morning, the smoking example, would it be possible to form a consensus objective view as to whether smoking is or is not a good or a bad thing? Views would differ over time. If the focus, though, is on whether this petitioner, it's reasonable for this petitioner to live with this respondent in light of the findings that have been made, that's as much an objective analysis. It's removing, as it were, the decision from the petitioner. It's not a subjective determination, it's an objective analysis based upon all of those factors that have informed consideration of the statutory test. Is it reasonable? And it would be arbitrary, in my submission, to introduce at that point some unfathomable, unspecified, almost unattainable standard of conduct that is or is not acceptable. Not least for the reasons we discussed this morning about the Ash case, for example, the violent and the violent, the drunk and the drunk, for example, the alcoholic and the alcoholic, for example. May I just say something in relation to the course of the trial? I don't want to get into this too much, but in essence, what happened at the case management hearing, and you will have some familiarity, perhaps some more than others, if I may put that without being disrespectful, at a case management hearing in a contested divorce, there are specific questions that the judge has to address. Venue, curiously still, who are the witnesses going to be, what's the time estimate, is there going to be any disclosure, etc., etc. So in a sense, the case management hearing order is formulaic and dictated by the rules. I suspect my reaction when it was suggested this case should be listed for 3 days was somewhat surprised. Whether my half-day time estimate was anything other than forensic posturing, I can't now recall. But the compromise that was reached was a day. And another direction made at the case management hearing, and we could let you have the order if you wish to have it, it's not in the bundle, was that, for example, the witness statements would be limited to 10 pages, and that they would stand as evidence in chief, subject to any direction of the trial judge. And what happens right at the point before I start, I call my client in chief, is the learned judge said that you can ask some supplementary questions if you want. I just want 5 or 10 minutes to get a flavour of the witnesses. Not unusual. It would, in my submission, have been altogether outside the ambit of what had been envisaged at the case management hearing, and indeed in the invitation given to me by the judge, to then embark upon a detailed or indeed even summary analysis of the behaviour and or its cumulative effect, precisely because that had already been dealt with in my client's witness statement. That was the purpose of the witness statement, standing as her evidence in chief. And as I said to the judge, the learned judge, in her witness statement, she had confirmed the veracity of the contents of her petition. She didn't have to go through it all again. Now, I made reference this morning to the chronologies that my learned friend and I had both put in. I wasn't going to take you to it, but may I do so just very briefly? And I want to come back, if I may, then to a point that Lord Wilson made. Although there was some measure of agreement as to how the case progressed on the day, each of the parties had, of course, marshalled all of their evidence, both positive and negative, in their documents. And so, if, please, you would turn to Core Volume 2, page 320, you'll see there that on behalf of the wife, we had filed a detailed chronology, and so you can...
Sorry, which page are we on?
I beg your pardon, my lord. 320 in Core Bundle 2.
Yeah, thank you.
Behind tab 13. And so what one can see on page 323, I beg your pardon, I then set out in a formulaic, albeit summary form, each and every one of the allegations and the response to it. It wasn't verbatim, but it was a summary of each point. And so if please, if one looks at page 324, 17th of February, unpleasantly suggests lost email is in W's secret address. H's comment designed to bring up. H admits the comment but denies being unpleasant. And then the next, again, a reference to, I wish the third party had not dumped her as they would be ensconced in France. H admits the remark in response to a provocative remark from the wife, and I cross-examined him about that, and he wasn't able to recall what that provocative comment might have been. And so a good deal of the husband's response was, in a sense, confession and avoidance, or taken out of context, or I didn't intend to be sarcastic or hurtful, etc., etc. And I know the court will have looked at that. Similarly, if one goes forward to page 345, my learned friend had undertaken exactly the same exercise. We didn't have a agreed chronology. We each spent time producing our own, as it were, but you can see my learned friend on page 345 colour coding blue for paragraph 3 and red for paragraph 4. So the event is set out, the husband's response, and then my learned friend's comment or submissions. And so, for example, if one goes to 347, number 3, 17th of February, W was looking for email, reference to the secret address, and then my learned friend comments. This was only 3 months after he'd been confronted with W about her relationship. And if we go to Judge Tolson's judgment, which is in Core Bundle 1, at page 215 it starts, but then one goes to where he deals with the affair on page 219. He took the first and then a random entry in relation to a suggestion that at the bottom of page 219, the petitioner took 9 pictures to depict the framers, which was time-consuming. On her return, the respondent told her in an accusatory and unpleasant manner that she had taken her time and sarcastically comment, "He must have been an interesting framer." Now, the learned judge deals with those 2 isolated examples, the very first being January of 2013 and this being February of 2014. But forgive me asking you to jump around. If one goes back to my chronology, just because it's I hope, a not unhelpful visual aid, as it were, on page 324, to suggest that these were isolated incidents, page 324, it starts on the 17th of February, and then you can see there's incidents on the 17th, the 21st, 2 on the 25th, 1 on the 26th, 2 on the 27th, 1 on the 28th, and 1 on the 1st of March. And to suggest that these two examples that the learned judge had examined on page 219 were of no consequence, they were taken out of context, they were not part of a course of conduct, it is simply to divorce them from the chronology of which they are part. Because you can see at the bottom of page 325 that the comment about the picture framers, something of and in itself that might not be of particular significance, is preceded the same day by what we've termed the housekeeper incident, the go out and pick up the cardboard from the garden. Do you see that on page 325? Criticise and reprimands, just by the letters B12, that was then pagination of the trial bundle. H criticised, reprimands W in front of the housekeeper. She felt she was being chastised like a child and was extremely embarrassed. W misinterprets H's reasonable request as a reprimand. So on the same day as that, we've then got the picture framer incident. Now, whether that becomes cumulatively more relevant or not, the learned judge simply didn't put these matters in context. And the very next day, the 28th of February, H brings up W's affair with the third party. H snaps at W and raises his voice. He says he will continue to bring up the affair whenever and for as long as he liked. H intended W to feel uncomfortable and to make her feel guilty. What is his response? She'd shown no remorse or apologised for the affair. He wouldn't have mentioned it if she wasn't. He would not have mentioned it when W said she was going to the French property. So he admits he said that the day after. I appreciate. Forgive me. I'm falling into jury territory, and I'm ineffectively inviting you to take a view. But my criticism is not, please substitute your own primary findings of fact, because at no point in my submissions have I sought to gainsay the observations which are summarised in Re B by Lord Wilson and by Lady Hale and indeed by Lord Newburger as to the hurdles that stand in my way. My criticism is indeed the criticism that my Lord Wilson suggested, which is the judge just didn't go through the factual analysis. And then he criticises the wife for relying on, in inverted commas, isolated incidents, which actually he, the judge, knew were not isolated. And similarly, my top four, which is on page 220 of core bundle 1, I was asked to name 3 and I named 4. The judge dealt with 2. He dealt with the airport. He dealt with the pub. He didn't deal with the housekeeper incident at all, and neither, in my respectful submission, did my Lord the President when absolving, as it were, the judge for his fact-finding analysis, although he sets out in his judgment the allegations and the response in the answer, it is simply overlooked that the judge did not deal with the housekeeper incident. And he didn't deal with what we term the restaurant incident. And indeed, His Honour Judge Tolson allies the two into one, in a sense. We can see that in paragraph 14. Although he, in the third line down, he refers to the airport incident, the restaurant incident, the pub incident, doesn't refer to the housekeeper incident that I'd postulated as of relevance because it was involving a third party in public. He then goes on to deal with the airport, and then he says, about 6 or 7 lines down, the airport and restaurant incidents are examples of 2 arguments in public which allegedly show the husband being domineering, and the pub incident is an evening of obvious silence over dinner. This case might have found favour if I had been satisfied both that the incidents were examples of a consistent and persistent course of conduct. Well, I've made my point about that. And took place as the wife described. I do not so find. But although he absolved the husband, as it were, in relation to the pub incident by saying, I accept his case that he was tired, he said nothing of the restaurant incident. We're straying into pinprick territory, as it were. But the husband's response to the restaurant incident was, the petitioner was very rude by talking to the waiter, so I did embarrass her, but she brought it upon herself. Now, some assessment had to be made of that. The judge simply ignored it.
But you can see the approach that he was taking, for example, for the beginning of paragraph 13. It was a sampling approach, wasn't it? He says, any other example from this same batch of allegations can be taken. He wasn't ignoring the existence.
I understand that, my lady, but the complaint I make, in a sense, is that the examples he takes are not of and in themselves placed in proper context. That's the complaint I make. And that's relevant for at least three reasons. One is the who, what, when and why. One is what was its impact upon the petitioner subjectively. The third is the cumulative argument with which he did not deal. And you have the President's judgment in relation to the cumulative point. It was obviously the point that interested his lordship the most, but he resisted my temptation to attach any weight to it in a way which, it's on page 204, talking about in paragraph 72. I agree with Mr. Dyer, it's about 5 lines up, that read as a whole and taken in context, use of phrases a consistent and persistent course of conduct, isolated incidents, criticism of the wife for cherry-picking, his reference to all other allegations in the wife's case generally, show that he was indeed looking at all the circumstances and to their cumulative effect. Well, those are two different things. Looking at all the circumstances and looking at their cumulative effect are two very different things. The cumulative effect of and in itself assumes a finding had been made at Balraj step 2 as to the subjective impact upon my client. I don't take you back to what we've set out in our case about that, but nowhere is any of this mentioned. Very briefly, I'm very conscious of the time, forgive me. If I can find my note. There was 2 very short points. They're very short indeed. My Lord Mans asked about the public interest in preserving marriage. May I, without drawing any attention to it, but simply so that you have it if it's thought to be relevant, at Core Bundle 1 at page 73, we set out, of course, the field of choice Law Commission report at the bottom, and your Lordship will see, it's, as it seems to us, this is a field of choice, a good divorce law should seek to achieve the following objectives to buttress rather than to undermine the stability of marriage. Now, whether that is relevant to your Lordship's point or not, I don't know, but it was certainly something that the Law Commission had in mind. I think both the Law Commission report in 1990 and indeed Nuffield in 2017 said neither of these objectives are being met by the present divorce law, and that's a gap of some 17 years. The final point I was going to make, and it was in relation to my Lord Wilson's point about whether the judge was actually concerned with the cause of the breakdown of the marriage, was just to draw to your attention at Core Bundle 1, page 263, Mr. Owens' statement as to how he put the case, or the case was put on his behalf, to the judge. And you will see at paragraph 3 under the heading Summary, in summary, my case is this: my marriage with Teenie has not broken down irretrievably, etc. I would hope she'll come back. If, contrary to my belief and wishes, the marriage has irretrievably broken down, then it's not because of my behaviour that my behaviour has been so grave as to cause that breakdown. Rather, the breakdown has been caused by the petitioner's admitted adultery with the third party, and possibly because she has become bored with our marriage and or disenchanted with me. The short point, of course, is that if he was right about that, and it had irretrievably broken down, and if he was right that the cause was my client's adultery, then applying Stevens, it would still have been open to the judge to go on to consider whether the respondent had behaved in such a way that it was not reasonable for my client to continue to live with him. And so the cause, as it were, was placed, what is the cause of the breakdown of the marriage was placed very firmly before the judge, at least in the respondent's witness statement, in the way that is then perhaps reflected in the paragraphs 1, 7 and 15 to which Lord Wilson drew attention. It's not a point that we ran below. It's not a point that I would propose, given the time, to develop any further at all, nor in relation to the European Convention point. I think the recent authority to which Malone and Fred made reference was one that, in the best traditions, as it were, I drew to Malone and Friend's attention before the Court of Appeal hearing, and so we really didn't press, although the President says that we were actively running the argument, we really didn't press the point before the Court of Appeal. Mr. Nagpal, I think, was primarily responsible for the section on European Convention of Human Rights in the intervener's document. He's not here, and I don't propose to argue his points any further. Unless I can assist any further, that's all I would wish to say in reply.
It looks to me as if you cannot assist any further, Mr. Marshall. Well, thank you to everybody concerned, not only those from whom we've heard on their feet, but those who I'm sure have made a contribution to the preparation of the interesting submissions that we have. We must now go away and try and work out what the answer is. We do not underestimate how important this is and how sensitive this is for everybody who's involved in the case, particularly the two principal parties. Whatever the outcome, we understand that. Court is now adjourned.